The Colorado Supreme Court has decided that Donald Trump engaged in an insurrection against the United States of America and should not appear on Colorado's presidential primary ballot. That decision in Denver today became international news within minutes, and now it's almost certainly headed for the United States Supreme Court for a final ruling there. Colorado's Supreme Court held today that Trump's incitement of the insurrectionist mob was not protected free speech, and that a Civil War-era ban on insurrectionists holding office applies to him as well. Let's bring in Marshall Zellinger now to break down the decision.
Yeah, the decision, Kyle, comes with an asterisk because once this gets appealed to the U.S. Supreme Court, this decision is stayed, meaning on hold. So Trump's name may still be printed on Colorado's primary ballot because the Secretary of State needs to certify the names and send them to the printer on January 5th. Colorado's presidential primary is 2 months later, March 5th. That's why this was such a swift case, from September's lawsuit challenging Trump's eligibility because of insurrection in the 14th Amendment, to the November trial, to this month's state Supreme Court hearing. The 7 justices, all appointed by Democratic governors, were split on this decision 4-3. The majority saying that yes, Trump engaged in insurrection and the 14th Amendment disqualifies him because of that. In the opinion, the 4 majority justices wrote, "We conclude that certifying an unqualified candidate to the presidential primary ballot constitutes a wrongful act," meaning Republican and unaffiliated primary voters in Colorado should not be able to vote for someone if they're not qualified in the first place. Trump's team argued that this was not a state election law decision. The Colorado Supreme Court opinion continues, "Were we to adopt President Trump's view, Colorado could not exclude from the ballot even candidates who plainly do not satisfy the age, residency, and citizenship requirements." The majority of justices compared Trump's 14th Amendment disqualification to the same standard as disqualifying a presidential candidate for not being 35 years old or not being a U.S. citizen. In dissent, one of the justices disagreed with the speed of the case, writing, "Absent adequate due process, it is improper for our state to bar him from holding public office." The Chief Justice disagreed with that insurrection can be decided by a civil court, writing, "My opinion that this is an inadequate cause of action is dictated by the facts of this case, particularly the absence of a criminal conviction for insurrection-related offense." The opinion, Kyle, 213 pages. And one part I found really interesting is on page 33. The majority quoted former federal judge Neil Gorsuch, now Supreme Court Justice Gorsuch. It was a previous case that kept a presidential candidate off the ballot in Colorado because that candidate was not a U.S. citizen, and Gorsuch defended the state's ability to make that decision.
They're going to put that right back front and center in front of Supreme Court Justice Gorsuch for him to look at his own words and see how they square in this case.
Absolutely. And it's in both U.S. Constitution and Colorado Constitution about age, residency, citizenship. The question will be, is Section 3 of the 14th Amendment something that a Colorado civil court can decide?
Marshall, thank you. The Colorado